Good afternoon. It is Saturday at 4 o'clock, so it must be time for the senior moment. This is Connie Clark with Home Helpers, and I am delighted today to have a dear friend of mine, Jim Bendell. And he is an attorney with the Grupp Law Firm, and he is a wealth of information when it comes to legal issues involving seniors. I tell everyone he's taught me everything I know, which is dangerous when it comes to these kinds of issues. So, welcome, Jim.
Well, Connie, thank you very much for having me here. I'm delighted to be here and participate in this Saturday show.
You have so much information. Jim, what is your background? Where did you come to be at this point?
Well, I've been an attorney for 35 years, and over that length of time, I've done quite a few things, primarily in the field of litigation. And litigation is simply a fancy word for lawsuits, where you go to court or an administrative agency, and there's a dispute of facts, and a judge or administrator makes a decision. So early in my career, I was a criminal prosecutor. After that, for many years, I was an insurance defense attorney representing insurance companies in injury cases and workers' compensation cases, after which I represented injured persons in those type of cases for many years and still represent them in those type of cases. And I also have done and do criminal defense work and a great deal of litigation involving probate, guardianship, things that affect the elderly.
And people don't want to know that there's litigation involved when it comes to their seniors because they hope they have everything all laid out and no one's going to dispute anything and it's just going to run smoothly. And that doesn't always happen.
No, planning can avoid a great deal of litigation, and careful planning of your future financial needs, your needs for your family after you're gone, that can really reduce the amount of litigation. But even in a perfect world, it's impossible for you to have 100% prevention of disputes arising. And there are many folks who don't make any plans at all, and then they get into a financial situation or after their death, then siblings or adult children will sometimes fight over what's best for mom and dad or what's best for the disposition of their assets. So, yes, we're necessary because of the frailty of human nature.
What kinds of things should you do ahead of time? I know there's a lot of talk. You need to have a will, but there's a whole lot more involved than just having a will. There's some things you can do up front to kind of set the stage so that when you do die, that things will not be as confusing for your family to take care of.
Right, and our law firm does a great deal of estate planning and asset preservation planning. And so when people say, I want a will, what we sort of think of is in terms of the following documents. First, you'll have a will, sometimes a will and a trust, or a will or a trust. The difference is that in a will, you have a document you sign that takes effect upon your death, but until you die, it has no effect. A trust is a living trust is where you put assets, it could be a house, cash, stocks, or bonds, into a trust. And while you're alive, you are the trustee of your trust. And then upon your disability or death, a successor trustee is made. And there are certain advantages to doing a trust. I'm just going to give you one because the area is involved. We have clients who have properties in a number of states.
Idaho, Washington, right across the border.
Very simple.
Idaho, Montana.
Montana. If a person has, especially real estate in those areas, if a person just has a will and they die in Idaho, you have to have the Idaho will probated. Now, Idaho probate's not too bad, but if you have real estate in other states like Washington and California, you will have to have an attorney probate the will, what they call an ancillary probate in those states.
And so that goes through twice.
It goes through
once
twice.
In each state.
That's right, and it adds to the cost. And hopefully there's no real estate in California because they have exorbitant probate fees that are minimum attorney fees set by the courts. And it's just really, really expensive. Now, if on the other hand, you've placed all your real estate in trust, Then when you die, the trustee can transfer those real properties, those parcels of real estate, by simply executing a deed. The
No
deed's
court
recorded.
involved.
No, well, the only court would be, might want to still have a will probated in the state where you die, but not in all these other states. The reason why a person has a trust but may also want to have a simple will is as follows. First of all, we try to make sure that after the trust is created, we move your assets into the trust. Sometimes afterwards you buy something, a car, you buy some stock, and then you forget to put it in the trust. In that case, we have to deal with it by a will, and sometimes we use what they call pour over will, that the will says anything that I haven't already put in trust is hereby given to the trust. Another reason why you may want to have a probate proceeding, even if you have a trust, is a probate proceeding not only takes care of your assets, it takes care of your debts. So, for example, when you file a probate, the attorney will say, so-and-so died on such and such a date. He left a will, or she did not leave a will, in which case they use the laws of intestate succession. Now, a notice is put in the paper advising all potential creditors that they have a certain deadline, I think it's 120 days, depending on whether it's Idaho or Washington, to file a notice of claim.
To try to claim their debt.
Right, and it could be a hospital bill, it could be any kind of bill, utility bill. If they don't file those claims within the 120 days, they're forever barred. And the reason that is sometimes useful, even if you have good planning with trust and so forth, you could have somebody who caused a car accident a year and a half ago. Actually, in Washington, the statute of limitations is 3 years. May have caused an accident 2.5 years ago. And the personal representative who handles the estate can be personally liable if that person distributes the assets and doesn't protect creditors. So 2.5 years after a person dies, somebody files a lawsuit saying, hey, the deceased smashed into my car, I've been going to a doctor, I've just gotten around to filing a lawsuit. The nice thing about the probate proceeding, it just cuts that off. In other words, if that person doesn't file a claim within the requisite 120 days, then the personal representative can be confident that then when they go ahead and distribute the assets, it's not going to come back to bite them.
And you may not know that something happened a couple years ago. If you live in a different state and your parents live here and now they've passed away and you're trying to clean up all the legal issues, you may not know what happened to them 2 years ago because they may be too embarrassed to tell you. And then all of a sudden someone comes and says, you owe me this money. At least going through the probate, you're protected from that, even with the trust.
Right, and sometimes, we leave it to the judge, the client's judgment, whether or not to do it. If you have a person who, for example, has been out of work for 4 or 5 years, they've been at home partially disabled, there's a good chance they haven't done anything. They haven't run around a hot rod doing things like that. Go to the other extreme, you have somebody who's had a business, they've owned their own business, they've been buying, selling, they have vendors, they have bills, photocopy, Xerox guy comes and charges. Things like that just lend themselves to the risk that some bill out there just pops up.
Okay.
And another situation where you have a complex medical situation where there's been multiple providers. And we have had cases where even hospitals submit their bills untimely, and those are denied.
A lot of us have gone to the doctor, and several months later or whatever, all of a sudden you get a bill.
Even our family, we don't have a huge amount of medical bills, but we get bills that are 8-9 months old.
Yeah.
Dental bills. It's really common that the doctors sometimes use independent services, and these things fall between the cracks. And you don't want to be a personal representative who is personally liable for any bill. It's not a real happy experience.
And I know I've asked these questions because I'm dealing with this issue within my family. But if you put it into a trust, that person can still get tax relief, like homestead exemptions. They can still sell the property if they want to. Right. They're not restricted. It's just like they still own it. They can still get the benefits of
Right.
that.
Now, the state of Idaho does allow you, in fact, we've contacted Kootenai County, they do allow you to take the exemption on your
So you're not
homestead.
losing any
You're
of
not
that.
losing that. And a lot of times we'll do these revocable trusts. You could revoke at any time. Sometimes you do it irrevocable for certain tax purposes.
Mm-hmm.
But yeah, as long as you name yourself as the trustee, you're in the driver's seat. And the nice thing about a trust over a will is that a will, you have to die for it to take effect. Whereas a trust, you can have a clause that says it takes effect, the following parcels of property are given to whoever if I die. But if I become disabled, I nominate so-and-so as trustee to make these decisions for me while I'm still alive in terms of where I want my assets to go. Getting back to your question, the original question was, do you need more than a will? We also recommend what they call a HIPAA release. If you're sick, you're in the hospital, and if you're not able to communicate, you want your doctor to be able to communicate with whoever.
Is this like a medical power of attorney?
Well, it's those are two separate documents.
Okay.
In fact, I think I'll start with the medical power of attorney. A lot of folks sign living wills. My own personal preference is the medical power of attorney, and here's why I like them. The medical power of attorney says if I become disabled so that I can't talk or communicate with my doctor, I nominate, my husband, or if he's too ill, my niece or my son or something like that, to make the medical decisions for me. The living will, a lot of times folks will sign one that says if I'm on a respirator, I don't want to be kept on a respirator. If I have a heart attack, I don't want to be revived. The trouble is, then you start talking about all these different scenarios. So,
What if this and not that?
Well, yeah. For example, if you have your appendix out, you're on a respirator for a while.
Mm-hmm.
Now, I don't want to be snuffed if I'm having my appendix out. So now you have to have footnotes. Well, I don't mind being in a respirator if this happens, if that happens.
Yeah.
Then you have medical technology keeps changing. So this document now has to have pocket parts, and it, to me, it's terribly confusing. The other thing is a lot of folks, when they go to their doctor will have them sign a post. I forget what the acronym signs. And the trouble is, you go to your primary care doctor, you filled out one form, but when you went to your gerontologist, maybe you filled it out and you checked a different box. So now you've got these
all these things floating
you've
around.
Got dueling banjos of post forms all around. I like the one-stop shopping idea. You give a medical power of attorney to persons that you trust and love and with whom you've discussed your philosophies on end-of-life issues. And then you know that person's going to be asked. Then the HIPAA release is needed because several years ago, Congress passed legislation enhancing our privacy rights and medical records. So now, like if my nephew calls my doctor and says, well, Jim broke his leg, how's he doing? He can't
tell him anything.
So you have HIPAA release signed, and then the person to whom you've given the medical power of attorney, they can have full communications with your doctors. And we have clients who have maybe 2 or 3 adult children in different states. We have them sign it for 2 or 3 kids, so all their kids.
That way they can call and see what's going on.
Right. So what we recommend is the will, the HIPAA release, and the medical power of attorney, and then possibly the trust. Those are the 3 or 4 documents for advanced planning that we recommend.
And there's some other things that you and I have talked about. One of them is a special needs trust.
Right.
And we've talked about, you normally think of a special needs trust if you had a child that maybe had some special needs and you wanted to make sure that person was taken care of when you died. But we've talked about if your spouse has Alzheimer's, that you would need to have something like that to protect them.
Right, and this is where estate planning needs can change over the years. If a couple comes in our office at age 45 or 50, we may do one set of plan that works for them for the next 15, 20 years. Then flash forward to age 71, 72, one of the doctors says, there's some early indications of Alzheimer's, so then we need to rethink our plan. In an ideal world, Social Security, which we all pay into, would pay for assisted living, would pay for nursing home care, and so forth. Unfortunately, it's sort of a gap in our system. And unless you have private health, private long-term care insurance, or you're just very wealthy, the default mode for middle-class Americans is to have nursing home care paid for by Medicaid. Now, Medicaid, big difference between Medicaid and Medicare. Medicare is an entitlement program for which you've paid into. Medicaid is a form of welfare. So you have somebody who's paid into Social Security their whole life, and they get hospitalized, and afterwards they're just not able to go home. The first 90 days of nursing home care, Medicare will pay for. After that, you're on your own. So if you eventually deplete your assets, and there's other things that can be done to plan for moving your assets into protected status. But anyway, eventually, if you have to go on Medicaid, and $6,000 a month for nursing home care is typical, that's where the special needs trust comes in, and that's where money that you put in trust can be used for things that Medicaid will not pay for. So if you had, say, $80,000 or $90,000, and you wanted to use that for the care of your spouse who's now in a nursing home, if you just put that in a checking account for your spouse to use, he or she would be disqualified for Medicaid until that was exhausted. You put it in a special needs trust, then there are things like everything from toiletry items to maybe trips going back, traveling to church, or all these other things that enhance the quality of life that are not paid for by Medicaid. So they can still get funds from that to use for these things, but it will not disqualify them from Medicaid, and they can still receive.
And that's a big deal. We need to talk some more on that, but I need to take a break.
All right.
So we're going to take a break, and then we're going to come back and continue talking about the special needs trust, because that's really, really important, especially as you get older. We'll break and be right back.
17 minutes went fast.
Yeah, I sit and watch, because it does. We get to talking, and because I talk to people and they say, "Well, I can't talk for an hour." Oh, yes, you can. Oh, yes, you can. Trust me. So I want to go back and talk on that. Because if something happens to the caregiver, that will knock that person off, and they want to make off Medicaid if they don't have this special needs trust put in place.
Right.
So we really need to use that. So, okay, you ready?
Let me just clear my throat. Go
No,
ahead.
that's okay. Tell me when you're ready.
I'm ready.
Okay. And we're back with the Senior Moment. Again, this is Connie Clark with Home Helpers, and we have Jim Bendell, an attorney, and we're talking about a special needs trust and how a lot of people think about that they need that if one of their children has some sort of special need that they need to take care of and make sure that when they die that their children are taken care of. But we also talked about that's something you need if one spouse has dementia or Alzheimer's. You need to protect that person, because a lot of times the caregiver actually, their health decreases faster than the person they're caring for. And you were talking about how people a lot of times have to go on Medicaid in order to care for someone with Alzheimer's just because of the cost involved. Continue with that, please.
Well, we're taking a situation where we have middle-class folks, and maybe they're both retired, and one spouse has been caring for the other spouse at home. And maybe up until now it hasn't been medically complicated. Maybe have somebody come in once a week to change for a wound dressing change or something like that. But then the person's symptoms get worse. Sometimes you may have people with Alzheimer's who might get up in the middle of the night, just walk away.
And in seeing working with a lot of Alzheimer's people, that happens. Initially, the spouse takes care of that person for a year, 10 years, whatever. And then all of a sudden things start happening where they're unable to. The situation is so complicated with the person with Alzheimer's, they can't care for them at home anymore.
And in fact, statistics show that caregivers of people who have Alzheimer's have a statistically higher rate, I think, of either dementia or death or both. Because
they're caring for someone else.
Is incredible. So you have folks who already are aging, and they're having to, juggle all these balls in the air. They're not sure if they can really sleep through the night, if there's a medical emergency. So they finally get to the point where they realize they just can't care for the person at home. Now, when the person goes into a nursing home, a full-blown skilled nursing facility, as we've discussed, it's extremely expensive. We're talking $5,000-$6,000 or more per month. and that would quickly deplete a person's assets. After and below a certain amount, then you do qualify for Medicaid. But there are these extras. I mean, Medicaid is a welfare program, and it's bare bones, okay? And if you have a special needs trust, there may be types of care, treatments, even recreational things that could enhance the quality of life. Even to have somebody come in to read to a person, something that could enhance the quality of their life. And by putting that money in a special needs trust, the person still can qualify for Medicaid. Now, the trust has to be drafted carefully. It cannot pay for anything that Medicaid does pay for, because that is the magic words that poof, you turn to a pumpkin and it won't, and you'll be disqualified for Medicaid. But if it's drafted properly, then instead of just having $60,000 or $70,000 or $100,000
or whatever, 20,000. I mean,
20,000 that would just get burned up because it would disqualify you. It may last a long time, providing many years, enhancing the quality of life for the person in the nursing home.
And if you didn't have that, when that person would inherit that money, that would immediately take them off Medicaid. Then they would have to go through spending all that money, and then they'd have to qualify for Medicaid again. So it's just so much easier to
Right.
put this in place, because you never really know. You may think, well, no, I'm going to outlast them because the Alzheimer's eventually, some complication of it, they will die. Well, what if you're in a car accident? I have seen caregivers, their health diminish while they're trying to care for somebody. So this is really important as you get older, if your spouse has Alzheimer's, for you to put in place to protect them. Another thing having to do with that whole subject has to do with guardianship. What is guardianship, and what does that do or not do?
Right. Now, guardianship is designed to protect a person who either financially can't make their own decisions or in total life circumstances can't make their own decisions. Typically, it's the result either of a serious accident. We've had clients with serious brain trauma at any age, or through advanced age with Alzheimer's, dementia, any number of conditions. And that a guardianship is a formal proceeding where you file an action in court. Usually an adult child of an older person or a niece or nephew comes in and says, look, mom or dad just spent $10,000 for a new roof, and there was nothing wrong with the roof. They're being exploited, and people are calling up with marketing, and they're just going through money. And a lot of times this is done through fear. We've heard a lot, I don't want to pick on the roofers, but I've heard a lot of situations where they go and say, ma'am, your roof, we just looked at it, gave you a free estimate. If it's not fixed this winter, you're going to have ice dripping. All these fear things.
Yeah.
Okay. So your mom or dad is making financially irresponsible decisions. Then the attorney goes to court on behalf of representing the niece, nephew, or son or daughter, and asks for either conservatorship or guardianship. Now here's the difference. The conservatorship is for a situation that says mom or dad is okay making everyday decisions. They can cook, they won't leave the stove on all night, they're safe and so forth. But financially, the checkbook is bounce. They're paying the wrong bill, the wrong utility. So that is the tiniest form of guardianship, where the court says, look, that person still has the right to make all their decisions. They can marry, they can vote, and all these other things that you do in life. But for financial, the court says we're appointing, Johnny or Sally or daughter and so forth as the conservator of that person's financial estate. So that if somebody tricks the old person to assigning a $10,000 loan, it has no meaning. It's valueless. Okay. The next level of intensity is the full-blown guardianship.
Well, can I ask you something about the conservatorship?
Yeah.
Is that when they would appoint the person and they would serve as a fiduciary, where they would have to report back to the court an accounting?
Yes.
So it's not just that you're giving all access to grandma's money to the niece who can spend it like they want to. They have to report back to the court an accounting of how they spent that money.
Oh, yes, the court has
Okay.
very strict reporting requirements. Now, the forms are, and a layperson could, you don't need to be an accountant to do it, but you do have to report to the court how the money's spent.
So you're not just giving someone free access to all their money. They have to report back
Right.
an accounting of how they spent that money and why they spent it.
Absolutely.
Okay, I kind of wanted to throw
yes,
that out there because
That's right.
a lot of people are afraid of that if I give up my control of my money, I'm going to give it to my daughter or my niece or whatever, and it'll be gone in 2 months. That's not the case. They have to give an accounting of what they've done.
Right, and in terms of the sort of the timeline of how this happens, I should distinguish between a conservatorship versus a financial power of attorney. Some folks, very wisely, as they see that they're having health problems, will say, look, I'm not even going to wait for guardianship. I appoint my daughter or son, or sometimes son and daughter, as trustees of my estate, and give them financial power of attorney so they can do that now. So we have clients who just give their son or daughter the checkbook. Look, you pay the bills, you take care of this for me so I can enjoy the things that my golden years. Now, the difference between that and the conservatorship is this. If you give your son or daughter or friend durable financial power of attorney, they can handle your finances, but you still also have the power to handle your finances. So if somebody comes and has you, somehow deceives you into signing a contract,
And you buy that $10,000 roof?
you owe the money.
Okay.
Whereas the conservatorship sort of puts an insulation over you so that no matter what you sign or what you're tricked into, you're not liable for that. Okay, so those are the difference. The other difference is the financial power of attorney is something the person willingly signs on their own. The conservatorship is something that's done by a court order, and the law requires that the proposed ward, they call the ward of the conservatorship, be served with a copy of the petition for conservatorship or petition for guardianship. In theory, that person can not only hire their own attorney, but the court generally appoints them an attorney, and they don't have to pay for it, generally paid out of the estate assets, to represent them, to make sure two things. One, do they really need a conservatorship?
Is there really an issue?
Is it really an issue? Two, is the proposed conservator a reliable, trustworthy, and honest person? Okay? And three, Idaho statute requires that the court impose the least restrictive type of regulations. That's both for conservatorship and guardianship. That is to say, what degree of liberty and financial or whatever flexibility is consistent with that person's compromised health. So, like I say, there'll be a court-appointed attorney to make sure that person's interests are represented. Now, when you go over to the guardianship...
Can I ask one more question?
Yeah, sure.
The financial power of attorney, that person, if you just sign that over, they don't have to report back to the court how they spent that money, do they?
No, they don't. So
that's one of the
very-
differences.
Right, and you definitely want to be very careful who you give a financial power of attorney.
So if you just sign a financial power of attorney, they can spend it all in 2 months and it's gone.
It's
Versus conservatorship, it has to report back to the court how you spent their money.
Right, now keep in mind, in both situations, they could be spent all in 2 months and they're gone.
Right.
But the difference is, in one case, a financial power of attorney, you could sue them. If they do it in the conservatorship, they could be held in contempt of court. But if you have a really devious person, they're probably gone with the wind. And
Anyway,
so you have to make sure that persons to whom you give this power or who get this responsibility are both honest, trustworthy, and also competent. There are some really good people who are not good with paperwork and finances, and we see this, sometimes we'll have several siblings, and, you'll have one who's sort of the salt of the earth type, but they're just not really business, they don't have a head for business, so maybe that person's not the best. Or what we sometimes see is a co-trusteeship or co-guardian, co-conservatorship, where you have maybe 2 or 3 siblings are appointed to have this power, so they confer to figure out what's good for mom or dad.
Yeah, I just wanted to throw those things out there because I know those things happen, and you've got to be really careful what you set up. You might think you're setting something up, and when it comes down to it, you're not protected. So, okay.
That's a danger.
And now going into,
The
Guardianship.
Now, this is for the person who has even more health compromises. This is the person you're worried about, may leave the stove on all night or just walk out of the house, or maybe.
And this could be an Alzheimer's.
It could be Alzheimer's, dementia, person after a stroke. I think a definitive diagnosis of Alzheimer's technically can't be done until autopsy. So you have people that have neurological compromises of some sort, or they're
Different types of dementia.
different types, and maybe they have differential diagnosis, but it's just not working in their life right now.
Right.
And for that person needs extreme protection. So in that case, the person is both the guardian and the conservator. So they get to decide where mom and dad lives,
Okay.
where the assisted living facilities, and what if
They make all decisions.
they would even mom or dad wanted to remarry, they couldn't do it without the consent of the guardian. So that is when the person really does have complicated health issues.
And they would go through the same process where it would go in front of the court. The person that they're speaking about would have a court-appointed representative to
Correct.
represent them.
Correct.
To make sure there really is an issue.
That's right.
Do they bring in doctors or sign statements or anything like that, or how would the attorney representing them know that whatever their situation is real?
When the petition is filed, the judge will appoint an attorney to represent the injured person or the ill person. He will also appoint what they call a visitor. Okay, and a visitor is somebody, since the judge has to sit on the bench all day, and he can't go around to talk to the
Check all
relatives
this out,
and
yeah.
go to the proposed resident place. A visitor is somebody typically with a experience in social work, something like that, and the visitor acts like an investigator, and he talks with the disabled person, he talks with the children, and he talks with the doctor or doctors. In addition, the judge will generally order that the person's primary caregiver file a report with the court advising as to what their opinion is of the person's disability or incapacity.
Okay.
Now, as far as evidence is concerned, if it's going to be a disputed case, it's like any other thing. It could be set for a trial, and you could subpoena other doctors to come in and say, wait a minute, my primary doctor may say this, but we've retained this doctor who's maybe a gerontologist or he's a neurologist who said, this mom is not really that compromised. Her vitamin D is low. If she gets enough fresh air and so forth, she really doesn't need this type of deprivation of her liberty, that she's able to function. So yes, it can become a debate between the doctors.
He said, she said kind of thing.
Yeah, or legitimate difference in medical opinion.
Wow. There's just so many ifs, ands, or. But we're going to take one more break. But Jim has just got so much information. I love talking to him because I always learn something else. So we're going to take a break, and we're going to come back and continue this discussion. We'll be right back. Every time I talk to you, I learn something.
Oh, thank you.
Oh, my goodness, I do. It's just, Okay, so we've talked about guardianship, and we've talked about probate, trust administration, and disputes.
That's really important, because we have a lot of cases where you'll have a trust set up. And there's a good thing about trust. I told you the good things about trust. Some of the times you have the alpha sibling is named as the trustee, and they sort of bully the other siblings in terms of what's happening with the money. And this is one of the areas where you're talking about, will versus trust. A will is probated under the thumb of a judge. And if somebody's having monkey business, you can bring a motion hearing before the judge. In a trust, it's sort of like you're out there on your own, and we see fights among siblings of how the trust money's being handled.
Okay, and then what about litigation against abuses of the elderly?
Yeah, this would be both financial exploitation and nursing home cases.
So we're going to talk. How about those two things?
Yeah.
Okay. And we're back. Again, this is Connie Clark with Home Helpers, and we're on the Senior Moment. And we're talking with Jim Bendell, who is a local attorney with lots and lots of years of experience. He must have been 5 years old when he started in this. But we've been talking about different forms of protection and different legal avenues to take with different situations having to do with seniors. And we've been talking a lot about different kinds of trusts, special needs, living trust, those kinds of things. And you had brought up that there's a lot of times disputes in families that I can't believe having to do with trust administration. What happens there? Because I know before people die, you have disputes among siblings, and I've seen after someone dies, it just sort of mushrooms. So, what kind of things have you seen happen with that?
A lot of times where you have multiple siblings or multiple heirs of an estate, there's a dispute over how money's to be divided, how property is to be divided, and a lot of times it's a simple matter of greed, I'll use that word. Other times it's a rehashing of old family wounds that go back for years. So you might have a situation where mom or dad has appointed, sibling A,
The oldest of the kids.
the oldest, or to be the trustee,
Or the oldest daughter of the kids.
or the oldest daughter
Yeah.
to be the trustee. Then after they're gone, in terms of managing the division of property, valuing the property to determine how it's apportioned, there are old wounds that are opened up about, you were always mom's favorite, or the person whose name is trustee is, I always had the responsibility. Everybody else got to have
Well,
fun.
and like in my husband's family, his mother left a will and it said this, but she always said, this son, I don't want to get anything because he was always borrowing money from me and never gave it back. Well, nothing was ever changed in the will. So then when it came down to distributing everything, everybody went, well, wait a minute. Mom always said, and the one that was administering it went, well, that's not what the will says. And so there was like arguments going back and forth as to how it, and it wasn't a lot of money. And that went on for a couple years, so I can imagine when you're talking about substantial money, that can really explode.
Well, not only substantial money, but also a person typically leaves a lot of personal effects. Things they bought on a trip to Europe, maybe handcrafted items.
This statue, this chair,
and
whatever.
The dollar amount may not be high, but I've seen real tugs of war over these items of property. And like I say, these are just a sort of an arena to vent old wounds and so forth. That is why sometimes folks, when they do trust, they hire a professional to administer the trust. There are professional agencies that do trust administrations. Other folks will name an accountant or an attorney. So there's somebody who basically has no emotional dog in the fight, who's just, makes a rational business decision. Okay, this is what the trust says. This is what your mom or dad asked to be done, and I'm going to do it the best I can. And, one of the things you can do is, as far as these little personal effects and knickknacks, you can leave a list of who gets what. Typically, a lot of times, a standard will say, in addition to the provisions of this will, and may leave with it a personal list. And these things that are not real expensive but have emotional attachment have it all spelled out. Therefore, there shouldn't be a lot of fighting. But no matter how carefully you plan, who you name affects whether or not there's going to be a fight, because you have to think of the personal dynamics. In other words, if I name so-and-so as a trustee, is this a person who plays well with others, okay?
Yeah.
If not, you may want to either have a co-trustee situation, name another person, or maybe name an accountant to do it, somebody who take an objective, independent view and avoid all the emotional angst involved.
Yeah, I have seen not only in my family, but in working with families, you see all of a sudden the whole dynamics change. When someone passes away, like you said, this little statue means absolutely has no money value whatsoever. But mom always said I could have that. No, mom told me I could have that, And I've seen people take masking tape and put them on the bottom and write someone's name on it or something like that. It just really gets involved. I can just imagine. And one of the other things that we talked about was litigation having to do with abuses against the elderly. What kind of things do you see with that?
Well, first could be the financial. probably seen maybe on 60 Minutes or something, people who are financially fleeced by Bernie Madoff characters. Now, of course, his victims were a lot of them Hollywood movie stars that were, millionaires.
And it's not only strangers, but it's families.
That's right. But this takes place on a much smaller scale. I've seen people just loan $30, $60, $100,000 to somebody for a business reason, no written contract, no agreement, no security interest, and the money's just gone. Now, if you're young and do that, all you can do is, you could try to sue them to go after them. If you're older, one avenue of litigation is just to sue them for fraud. Another avenue is to sue them on the grounds that the person who you represent, the older person, lack the necessary mental capacity to form a contract. Now, both of these would require, though, that the person you're suing has some assets. Unfortunately, a lot of situations, these scammers take off or they've hidden the money someplace, and there's not much you can do
and
about that.
It's nowhere to be found.
Right, and that's why we talk about the careful planning. And then another way that older folks are exploited is, unfortunately, some nursing home cases involve a lot of negligence. A person in a nursing home often can't speak up for themselves.
Or are afraid to.
And so you have people that are not, for example, bed sores are not treated for a long time. They have necrosis, and they have horrible complications set in. Now, there are federal standards for nursing home care in terms of staffing and so forth, and that if those federal standards have been violated, you have grounds for a lawsuit to recover financial damages if somebody, an older person, was mistreated and suffered injury or even death in a nursing home.
And I know locally we have the Area Agency on Aging who and has the Ombudsman program where if you have a nursing home or an assisted living that something's going on you don't like, you can bring them in to see if they can work with it. And they also come in when there's abuse of the elderly at home.
Yes.
But sometimes we have run into situations where we see things happening in the home and they come out and they do an interview and the people in the home go, hey, there's no problem here. And if the person being abused at that point doesn't admit to the abuse, then it doesn't stop. And so if it doesn't stop, that's somewhere you would come in and start helping them.
Right, and sometimes older folks are fortunate enough to get a friend or somebody who's going to speak out on their behalf, because if they're at home in a situation where there's a strong personality having them under the thumb, it is hard for them to speak up. It's almost like cases where you hear about abused women who are in horrible relationships. They're afraid because if they speak up and then the attorney leaves, then it's going to get worse. They'll be beaten or something like that. So a lot of times, in a situation like that, you may have to almost go and get a temporary restraining order to get them out of that situation. So that's where it really helps for them to have some friend or something who can bring it to the attention of either a government agency or the attorney that says, this person is being exploited, they're not being fed properly, they're not given their medicine, and or their assets are being depleted. We had one case not too long ago. I was peripherally involved, where a person who she was in her 80s, I think, had a cousin who she hadn't seen for years. Came to her room, and there was a nice family taking care of her, and they hear this screaming and yelling, and this cousin convinced this woman to write a check to give him $10,000, that he owed it to her, that he's in the family, and that he's down on his luck. And she gave away like half of the assets she had. She just got browbeated into it. So, the elderly can be the victims of all types of financial and physical exploitation.
Well, and a lot of times their cognitive ability is not there for them to think things through, or they're afraid, or, they don't want someone to be mad at them, or they want to help somebody, and they're just such easy targets. But there are so many different things. We've talked about a number of different things that you can put in place to protect the person, to protect the person's assets. But the important thing is to do it.
Right.
Not just to wait.
Right.
Because you don't know. Yeah, you don't know what's going to happen. I mean, you could say, okay, well, next month I'm going to go, and then you have a stroke tomorrow. now what are you going to do? Your ability to communicate is gone, all of that, and you don't have anything in place. So it's really important to get this kind of stuff done now.
You do it well before you need it, because well before you need it, you're not operating in an atmosphere of fear. Because sometimes folks call us, so-and-so just went into a nursing home, what are we going to do? Then there's fear, panic setting in, and it's hard to make decisions.
Well, and you don't want to make a decision in a crisis mode either.
Right, exactly.
You want to be able to investigate all of your different options and see what's out there. Like example, my sister-in-law, her husband passed away a couple years ago. And we have been trying to get her, because I learned from you about the living trust. She had property in 2 different states. And she's got 2 children, 1 in each state. And, the issue is, okay, well, if you don't address this, something's going to happen. Well, she wanted to put one of the pieces of property in one of the children's names. Well, what happens if that child gets into an accident or something? She could lose her house,
Exactly.
And if something happens to her, both kids have to go through the probate process in each one of their states. And I don't know, it's just so frustrating trying to talk to somebody to convince them to do something like this, especially when they're afraid. They're afraid, well, if I go to an attorney, am I going to lose my house? Am I not going to have control of it? Am I going to lose my homestead exemption? What if I want to sell it? And it's
also,
just
people
fear.
are afraid to talk about these issues. When you go to the attorney, one of the things you're going to talk about is your death. And unfortunately, we're not going to live forever, okay? And so these topics need to be discussed. But who really likes to talk about, well, when I die?
That's a hard subject.
That's a tough subject. Or when I'm mentally unable to function.
Because then you're admitting your own mortality.
You're right. These are unpleasant. Now, it's like going to the dentist. The thing about the dentist, though, when your tooth hurts, you go, even though you don't like the sound of the drill. There's nothing comparable like that for lawyers. You have to be your own motivator. Say, look, I know someday I will die. I may get sick. My husband or wife may get sick, or he will die. And so how we're going to handle these things, go to the attorney now, just, get it over with, get the documents signed. Then you have peace of mind. Then you don't have to worry about it.
Well, and then I know we've talked before, you had a will made up 10 years, 15, 20 years ago. Well, who did you have as the administrator of that will? Is that some person that now lives, 7 states away from you, that at the time was your best friend, and now they don't even live near you, or maybe they've passed away? You really do need to update these things. And I've heard it said that you really want someone to administer your will that's more of a entity, because then no matter how many people leave that entity or whatever, that entity still exists.
Well,
Does that make sense?
There are professional management firms. I would say most of the wills that we do, we actually they prefer to name a person, or a lot of times they'll name a co-personal representative, both their son and daughter.
Mm-hmm.
If you have a very complicated estate, though, with many parcels of property, stocks and bonds, then it may be worthwhile thinking of a professional entity to do that.
Yeah, and if it's someone that's far away, it's going to be hard for them to come up here if they live in Florida,
right,
and take care of your estate.
Right. I mean, faxes and email has made it easier than it was in the past, but still, you should probably have somebody local. And we have situations where they'll have maybe one son, an adult child lives in Idaho, another one out of state. They can be co-personal representatives, and you have somebody local who can hands-on go to the house, see what repairs need to be done, go to a real estate agent to get it listed and so forth. But you don't want everybody administering the estate or the trust to be out of state. To me, that's complicated, unnecessarily complicated.
And whenever you do set any of these things up, you really do need to let your entire family know. I know I've talked to folks over at the hospital that they'll have someone come in that's had something very serious happen to them, a stroke, a heart attack, an accident, whatever, and they have communicated their wishes to local family. But then all of a sudden, out-of-state family starts showing up. And now they have a totally different idea, the out-of-state kids, that what mom or dad really wanted. And conflict arises, and there's this massive thing happening over at the hospital as to, no, I want mom to have this. No, I want mom to have that. No, well, mom really wanted this, And so everybody really needs to be on the same page when you
They need
set
to be on the
something
same
up.
page that mom or dad is on. So if mom
Yeah.
or dad says that Sally or Johnny is going to have the medical power of attorney, they're going to have to live with that decision.
Right. And especially when it comes to the living will kind of situations, the kids coming from out of state go, no, you're not unplugging her. I talked to her 3 years ago and she said she didn't want that, And so everybody, like you said, needs to be on the same page. This person is making the decisions, not a consensus.
Well, yeah, that's why I think the firm likes the medical power of attorney over the living will, because the medical power of attorney says Johnny or Sally gets to make that decision. If you have the living will, then you get this debate, this round table you're talking about. Well, it says here she doesn't want to be revived, but there's
This is different situation.
That's right.
Yeah.
Or this post you signed here last year with her allergist, that didn't say that. That's why you don't want to get into a big debate. You want somebody to make a decision. It's a tough decision, but mom or dad said that he or she was to make that decision.
And again, when we were talking about the HIPAA release, the hospital may not be able to talk to those kids about your situation.
Right.
I can't tell you anything. What do you mean you can't tell me anything? And that's my mom over there. So
Well, I remember years ago, this is many years ago. Anybody could call up and say, "I'm calling to get a status on Mr. John."
I
Smith,"
remember that.
and said, "Oh, he's doing fine, or he just had a stroke, or he's doing terrible."
Yeah, I'm her niece. They don't confirm.
So you can't do that anymore.
Yeah, and that's tough, especially when you've got people far away who can't be there. Yeah, if mom or dad's here and the kids are in another state, they can't call the hospital and find out what's going on unless you've signed that release.
Right.
Now, is that part of the papers that the hospital asks for when you're admitted? Do you have all of these things that you provide
I think
to them?
most hospitals don't ask for. What they ask for is, do you have a living will? Or they may have a form for you to sign. And I think a better practice would be to also ask, and maybe they do. I haven't been admitted to a hospital for many, many years for something minor, so I don't remember what they do, but it seemed to be wise for them to ask for that. They ask for who has a medical power of attorney, especially if you're something life-threatening, where they may have to make decisions.
And we've talked before about putting vital information in an envelope on your refrigerator so that when paramedics come, they have that information. You would probably want to keep the original someplace safe, but have copies of those documents in an envelope on your refrigerator so that if paramedics come, that something has happened to you, they can retrieve that information and have it, especially if you cannot communicate.
Right. Now, I don't know, do paramedics normally check the refrigerator door? Or
That's a lot of times that's where all the vital documents
Yeah.
are kept.
Yeah.
And if they've got an emergency button, they will have information that there are vital documents on the refrigerator. That kind of information is transmitted to them when you push the button. That's like if you have a key outside. The key's under the third stone to the right from the door, to get in the door, and the vital information's on the refrigerator or whatever. Those kind of things you want to make sure they know, because when you have paramedics come out, they ask you what all medications you are on, what conditions do you have a post form? And again, if you have multiple post forms,
Complicated.
yeah, that's a whole nother animal.
Right. So when you create these important documents, the will, the power of attorney, and so forth, it's a good idea to give them to several of the important people in your life. At the same time, you wouldn't want to make 30 or 40 copies, because we've had situations where somebody dies, and when the person made the latest will, they didn't tear up the old ones. And
So
then
there's
we have
versions all over the
different
place?
versions
Oh, my
all over the
goodness.
place. So you want to try to keep that real tidy and organized.
And keep track of who you gave
Keep
those
track who
to.
you give it to, right.
Well, I appreciate all this information. Every time I talk to you, Jim, I learn more things.
Well, thank you.
It's good and it's more confusing all at the same time. But if somebody has a question, can they call you over at the Grupp Law Firm?
Absolutely, 665-4600, and we have folks who could talk to you about these different issues, and we usually have an initial consultation without charge.
That's fantastic. I know you've been really great in answering questions for me when I've run into different situations, and I appreciate you being here.
My
And again,
pleasure.
if you have any questions, give them a call. You've got a couple websites, I know, that I've seen.
Right. You just Google my name, you get a website. I have for my own type of law. Then the Grupp Law Firm has a website. So nowadays everybody goes to the internet as opposed to the phone book. With that, that's fine.
So you have websites in addition.
Yeah.
And they are great for information. These folks are so good at what they do. And I appreciate it. Thank you for being with us today,
My pleasure,
Jim.
Connie.
Again, this is Connie Clark with Home Helpers, and you've been listening to the Senior Moment.